I have previously explained the doctrine of eclipse in my series on constitutional law. It is actually a very simple doctrine and concept which can be understood by looking at this picture. What happens when there is a solar eclipse? Well, the moon comes between the sun and the earth and eclipses or obscures the sun. So you cannot see the sun from the earth. The sun does not go anywhere. It is still there. It is just not visible. And when the moon moves away, the eclipse is removed and the sun will become visible again. In the context of constitutional laws, the doctrine of eclipse applies to pre-constitutional laws. That is, laws that were enacted by the British government in India and also on laws that were enacted by the Indian government after independence but before the constitution came into effect in 1950. In the Bhikaji Narayan Dhakras versus the state of Madhya Pradesh case, there was an old law from 1947 which allowed the state government to create a monopoly for itself in the motor transport business and exclude all private operators from such a business. When the Supreme Court decided on this case, it applied the doctrine of eclipse on the old 1947 Act. The court held that the 1947 Act, which was a pre-constitutional law, became void after the commencement of the Constitution in 1950 because the old Act violated Article 19(1)(g), that is, the right to practice any profession or carry on any occupation, trade or business. Because of the doctrine of eclipse, that part of the law which violated the fundamental rights became inoperative, which meant that the government could not create a monopoly for itself by preventing private citizens from carrying on motor transport businesses. But the old law did not disappear completely. It only became invisible or inoperative, and that too only to the extent where it went against the fundamental rights. The other parts of the Act, which were not contravening any fundamental rights, continued to operate as usual. Later on, in 1951, in the first amendment of the Constitution, the fundamental right under Article 19(1)(g) was amended with a qualifier that nothing could prevent the government from engaging in any trade, business, industry or service and create a monopoly for itself, which meant that the eclipse was removed and the old law, which allowed the government to create a monopoly for itself in the transport business, was revived and it became enforceable again.